All right, good afternoon, everyone, and welcome to the Maryland State Commission on Criminal Sentencing Policies, recent sentencing guidelines updates, and quick Q&A. My name is Catherine Pembroke. I'm the Administrative and Training Coordinator for the Sentencing Commission. The sentencing guidelines play a significant role in supporting fair and proportional sentencing practice. Accordingly, your participation in staying up to date on the sentencing guidelines, it's really important because it helps to promote the consistent and accurate completion of the guidelines. Now, the format for today's training, it's going to be a little bit different than past trainings. The purpose of this training is to provide a quick recap of recent sentencing guidelines and Maryland automated guidelines system updates, as well as a review of frequently asked questions relevant to this group of practitioners. Therefore, we're not going to be getting into the specifics of guidelines calculation. If that's something you're interested in, I'm going to be holding another training on Friday, April 11th, which will provide a more detailed review of basic guidelines calculation. So to get us started, I've already compiled a list of the more commonly asked questions. These questions we will be reviewing. They're going to cover a range of topics to include sentencing guidelines eligibility, specific areas of guidelines calculation, guidelines compliance sentences, and then we're going to review some considerations to keep in mind regarding MAGs. Now, even though we already have some questions to review, if we get to a topic that may be relevant to a question you have, I have some of my colleagues here who are able to monitor the chat box, so feel free to submit any questions through the chat box. I crammed a lot of material into this 30-minute session, so I'm going to try to move through it quickly. But at the end of the session, I'm happy to take any outstanding questions, and we will go from there. You should also be seeing a PDF of today's presentation coming through the chat box at some point in the beginning of the presentation here. All right, so to get started, let's look at a common question regarding guidelines eligibility in general. Now, do Maryland sentencing guidelines apply to misdemeanors? The answer here, yes. The sentencing guidelines apply to guidelines eligible misdemeanors and felonies prosecuted in a circuit court. Now, over the last couple of years, there's been some confusion with some practitioners thinking that the guidelines apply solely to felonies, and that's not true. Again, they apply to both guidelines eligible misdemeanors and felonies prosecuted in a circuit court. So let's take a look at the scope of the sentencing guidelines in greater detail here, just as a bit of a refresher. So as I just noted, sentencing guidelines apply to criminal cases that are prosecuted in a circuit court. The sentencing matters that you see on the left-hand side here, we refer to these as guidelines eligible sentencings, and they require a guidelines worksheet. So those include circuit court original sentencings, jury trial prayers and appeals from the district court, but only when a pre-sentence investigation is ordered, cases adjudicated via probation before judgments. This also includes the new type of PPJ pursuant to Criminal Procedure Article 6-220, subsection C. In addition to original sentencings, we also collect worksheets for guidelines eligible reconsiderations, modifications, and 3-judge panel reviews, provided that the sentencing event involves a crime of violence, and there was an adjustment made to the original active sentence as a result of that recent modification. Now, on the right-hand side here, these are sentencing matters that you'll also see handled in a circuit court, but they're excluded from guidelines coverage. So those include jury trial prayers and appeals with no PSI, offenses that carry no possibility of incarceration, violations of local laws and municipal ordinances, probation violation hearings, criminal non-support, desertion and contempt cases, juvenile court adjudications, and then finally, the guidelines do not apply to district court sentencings. So let's take a look at another guidelines eligibility question, just in general. Let's say you're having trouble locating a particular offense in the guidelines offense table and you're questioning why. The answer, it might be because it's not a guidelines eligible offense. So let's take a look at some of the questions about a couple offenses in particular I get questions about. So the first, as I just noted, violations of local laws and municipal ordinances are excluded from guidelines coverage. And I often get questions about this particular example here, discharging of a firearm, which is a violation of Baltimore City Code. Now, even though this particular offense does carry the possibility of incarceration, because it's a violation of Baltimore City Code, it's not considered guidelines eligible. So if it were being sentenced in a case along with other guidelines eligible offenses, it just wouldn't be reflected on the worksheet. Now, COMAR, which are Code of Maryland regulation violations, they are also generally not considered guidelines eligible. These can also cause some confusion because oftentimes they do carry the possibility of incarceration. Now, to make it even a little more complicated, it is possible there may be an exception if the penalty for a COMAR violation is outlined in state statute as opposed to COMAR itself. But again, generally COMAR violations, if the penalty is also contained in COMAR, are considered not guidelines eligible. So if you ever have a question about guidelines eligibility, in particular regarding these types of offenses, you can always feel free to contact us and we can confirm. And then lastly, I do just want to note that effective October 1, 2025, reckless driving does carry the possibility of incarceration and therefore has become a guidelines eligible offense. So previously it did not carry incarceration and it wasn't reflected on guidelines worksheets, but moving forward, you do want to reflect it on the guidelines worksheet. And finally, just to note, it's possible that some of the more infrequent offenses with a maximum penalty of less than 1 year may not be included in our offense table, but would still technically be eligible. So again, if you're having trouble finding one of those offenses, always feel free to contact us so we can confirm that it is not, in fact, in our offense table. And if that's the case, we'll discuss the next steps. All right, so moving on to some questions regarding the offense score. So quick reminder, the offense score is calculated for person offenses only. So those typically involving victims as well as weapon-related offenses. So let's look at a question specific to victim injury here. Now, what type of proof is needed to score psychological injury? And the answer, actually effective January 1 of this year, the commission actually expanded the definition of psychological injury. So let's take a look at those changes in greater detail here. So at the commission's September 9, 2025 meeting, the commission voted to expand the definition of psychological injury and specifically expanded the definition to state the following: that the sentencing guidelines recognize that not all victims have access to psychological counseling or treatment. Victims may not have been provided treatment, and the psychological impact on certain victims, for example, minors, may not manifest until later in life. Proof of psychological injury shall be based on 1, confirmed medical diagnosis or psychological counseling or treatment, or 2, other forms of reasonable proof. Then go on to clarify rape crisis hotlines, clergy conferences, educational counseling, and other similar services are considered psychological counseling or treatment. Further noting that permanent psychological injury shall be based on proof of a substantial impairment likely to be of an extended or continuous duration. So just to recap, prior to January 1, 2026, in most cases, there had to be some sort of documentation in order to score psychological injury. But with this expansion, now other forms of reasonable proof can be considered. So just something to keep in mind when you're looking at cases that may involve some element of psychological injury. So here's another question concerning victim injury in general here. Now, should non-permanent or permanent victim injury points be scored for offenses involving photographic or video evidence of child pornography? And the answer is that permanent victim injury points should be scored for these offenses. Now, this rule has been in place for a couple of years now, but I've realized just based on some conversations I've had with practitioners, sometimes if I'm reviewing a worksheet with them, I'll notice that these permanent victim injury points aren't being scored consistently for these types of offenses. So it's something that I want to highlight. And I also want to note that this rule, it's not limited to solely for convictions of possession, manufacture, or distribution of child pornography. Points can also be applied to other types of offenses as long as there is photographic or video evidence of child pornography. So again, just a reminder to score permanent victim injury points in those types of cases. All right, so moving on to the offender score calculation, we're going to look at some questions pertaining to the offender score, which captures basic components of an offender's prior record. So starting with, does pretrial supervision constitute criminal justice system involvement for the purposes of scoring Part A, that being the relationship to the criminal justice system when the instant offense occurred? And the answer, usually no. So let's take a look at why that is. Now, 1 point is scored for Part A if the offender was in the criminal justice system as a result of an adjudication as an adult at the time the offense was committed. So generally, when someone's on pretrial supervision, they haven't yet been adjudicated, which is why it normally wouldn't constitute criminal justice system involvement. However, it could be possible someone's on pretrial supervision, they've been adjudicated, and are still on supervision pending sentencing. So if the instant offense occurred post-adjudication and prior to sentencing, then it would constitute criminal justice system involvement. But again, generally, pretrial supervision does not. All right, so moving on to another question related to Part A. Does juvenile probation constitute criminal justice system involvement for the purposes of scoring Part A? And the answer is no. So just to clarify, with the exception of the juvenile delinquency component of the offender score, the remaining components refer only to the defendant's adult involvement in the criminal justice system. So this is why juvenile probation wouldn't constitute CJS involvement for the purposes of scoring Part A. All right, one more question relating to Part A. We get a lot of questions about Part A in general. So does the sex offender registry constitute criminal justice system involvement for the purposes of scoring Part A? The answer here, also no. So at the Commission's September 17, 2019 business meeting, this topic was discussed and there was a majority vote against including sex offender registration in Part A's definition of criminal justice system supervision involvement. So therefore, if the defendant was on the sex offender registry as a result of an adjudication at the time the instant offense occurred, as long as there was no other form of supervision taking place, meaning they were off, parole, probation, etc., 1 point would not be scored solely for the defendant being on the sex offender registry. All right, so moving on to some questions about the prior adult criminal record here. Now, should adjudications that were expunged from the record or proven by the defense to have been eligible for expungement as a matter of right prior to the date of the offense be excluded from the prior record score? So the answer here is yes. Now, a common instance of a prior adjudication becoming eligible for expungement, it may have involved a prior probation before judgment. Perhaps the defendant successfully completed their probation, 3 years has passed, no new charges. So technically it would be eligible for expungement. But just to note, expungement laws have expanded a lot over the past couple of years, and now even certain prior convictions are now eligible for expungement after a specific period of time. So just something to keep in mind when calculating the prior record. So next, I actually want to walk through just a basic example of calculating the prior record because it is the most complicated component of the offender score. So let's just walk through a hypothetical criminal history here. Let's say we have a defendant who back in October of 2018 was convicted of a second-degree assault and a resisting arrest. Now, by guidelines rule, when you have multiple adjudications that stem from the same criminal transaction, you're only counting the most serious offense towards the scoring of the prior record. So between the second-degree assault and resisting arrest, it's the second-degree assault that has the higher seriousness category, so the resisting arrest wouldn't be counted here. Then in March of 2019, the defendant was convicted of CDS, possession of cannabis. However, I was able to determine that that particular offense involved 2.5 ounces or less. Now, currently, possession of cannabis 2.5 ounces or less is no longer a criminal offense. Therefore, I would not be counting it towards the prior record at all. Then jumping down to July 2020, I have a conviction for a first-degree assault, and in 2022, destruction of property less than 1,000. Now, out of these 3 adjudications that I'm counting towards the prior record, it's the first-degree assault that has the highest seriousness category. And I only have 1 seriousness category 3 adjudication that I'm applying here. So when looking to my matrix, I'm going to look to the seriousness category column on the left-hand side, and then the number of adjudications within that seriousness category. So again, 1 seriousness category 3, I'm looking to the first box here, which means that the prior record would result in a moderate and then would jump to a major if combined with 2 or more offenses in categories 4 through 6, or any 6 offenses in general. So I only have 1 other offense that falls into this 4 through 6, that being the second-degree assault here, which means it would remain a moderate. However, let's say this destruction of property, let's say that was a second degree assault. So that would give me 2 additional category 5s, which would bump it up to a major here. All right, so I thought it'd be helpful just to walk through an example. Again, I know it's complicated. If you ever have questions about calculating prior record, always feel free to call us. All right, so let's look at some questions just regarding overall guidelines calculations in general here. Now, common question that I receive, if the indictment includes multiple offenses that were committed over a period of time, should they be treated as one criminal event or multiple criminal events? And the answer is that it really depends on the circumstance of the case. I know when many of you have called with the question, I can't really give a definitive answer. And I'll usually refer you to our definitions of single versus multiple criminal events. So let's quickly review them here. Now, for guidelines purposes, we define a single criminal event as one or more crimes committed in the course of the same transaction. Now, in determining that, you should be considering whether the crimes are 1, committed close in time in an uninterrupted course of conduct, 2, occur in the same location, and 3, are similar in nature or intertwined. So for example, whether they share a common scheme or purpose. Whereas multiple criminal events means more than one criminal transaction was committed over a period of time. Now, multiple criminal events being sentenced together, they may have occurred on the same date or different dates, but generally offenses that occur on different dates are almost always going to be considered separate criminal events. All right, so let's talk a little bit about the stacking rule here. We're going to start with a general question. Is the victim stacking rule limited to person offenses? So the answer here, no, it is not limited to person offenses. For example, if you had a case involving a theft scheme, if there were multiple victims, you could certainly apply the stacking rule and that type of case as well. So let's review the criteria for the stacking rule because it is probably the most common special application that adjusts the overall guidelines calculation. So to utilize the stacking rule, there must be a criminal event with multiple distinct victims. There cannot be more than one seriousness category 1 or 2 offense. So if you had a case involving, for example, multiple counts of murder, 1st degree, you wouldn't be able to utilize the stacking rule. 1 adjudicated offense per distinct victim may be used to calculate the guidelines. So if you have multiple offenses that relate to the same victim, you want to flag the offense with the highest seriousness category per victim for the multiple victim stacking rule. And again, only the upper limits stack. Now, another follow-up question specific to the stacking rule. Are animals considered victims for the purposes of applying the stacking rule? So the answer, effective October 1, 2025, yes. And I know that may be a little confusing because we actually had language in our manual prior to that date stating that animals were not considered victims for the purposes of applying the stacking rule. However, pursuant to Senate Bill 152, House Bill 89, each animal harmed in violation of Section 10, Subtitle 6 of the Criminal Law article shall be considered a victim when applying the stacking rule. So to note, this doesn't apply towards hunting or fishing offenses, but if you had an animal cruelty case involving multiple different animals, you would apply the stacking rule in that scenario moving forward. All right, another question, just kind of regarding overall guidelines in general. It's actually a question I get from parole and probation investigators pretty frequently here. So if a defendant has a prior adjudication for the same or a similar offense, should the subsequent offense entry automatically be selected when calculating the guidelines? So the answer, generally no. So Maryland Rule 4-245, that governs the subsequent offender notices and requires the state's attorney to serve written notice of prior convictions on a defendant or counsel at least 15 days before sentencing in a circuit court. So this notice is required to seek mandatory minimum or increased penalties based on previous convictions. Therefore, it's always important, for example, if you were doing guidelines for a DUI case and you were running the criminal record and you could see that there were prior DUIs, rather than just automatically selecting, the subsequent DUI offenses with the enhanced penalties, you want to confirm with the state, confirm whether or not they filed notice to seek an enhanced penalty due to subsequent offender status before automatically selecting those subsequent offenses. All right. Somewhat related, let's discuss another recent guidelines rule change that went into effect on January 1 of 2026. Now, at our September 25 meeting, the Commission voted to adopt instructions advising practitioners that subsequent violations of Criminal Law 4-204 and 306B apply to both contemporaneous violations and previous convictions. So specifically, the new instructions provide the following. When an individual is being sentenced for multiple violations, including contemporaneous violations, so happening within the same event, of Criminal Law 4-204, which is the use of a firearm in commission of a felony or crime of violence, or 4-306, which is the use of an assault weapon in the commission of a felony or crime of violence. The guidelines for all but the first violation of each offense shall be calculated pursuant to subsection C2 of 4-204 or B3 of 4-306, respectively, both of which provide penalties for subsequent violations. So these instructions are consistent with Maryland case law, namely Garner v. State and Gray v. State. So again, if you're calculating guidelines for a criminal event that involves multiple crimes of violence, perhaps multiple violations of use of a firearm and commission of a felony or crime of violence, all but the first violation of the offense, you should be selecting the subsequent violation offense entries for all but the first violation. So just something to keep in mind moving forward. Okay, so next we're going to turn the discussion to guidelines compliance sentences and review the criteria. Just important to keep this information in mind when making recommendations on a pre-sentence investigation and also just during plea negotiations. So as a reminder, a sentence is deemed compliant with the guidelines if the guidelines applicable sentence, which is defined as the sum of incarceration, credited time, and home detention time, falls within the applicable guidelines range. So just to note, generally suspended time is not considered when determining if a sentence is compliant. It's generally the sum of incarceration, credited time, and home detention time. There's one exception involving corrections options, but we'll talk about that in a moment here. I also just want to note that compliance is calculated by comparing the overall sentence across all adjudicated offenses in a sentencing event to the overall guidelines range for that sentencing event. So it's possible you could have a sentence exceed the upper guidelines limit for one offense in the sentencing event, fall below a second offense, but still the overall sentence, when taking into account concurrent versus consecutive nature, it could still fall within the overall guidelines range for the sentencing event. Now, a few qualifiers to consider regarding guidelines compliance. The first is that sentences adjudicated pursuant to an MSCCSP binding plea agreement are automatically deemed guidelines compliant. Now, binding pleas are three-party agreements in which the state and the defense present to the court on the record an agreement that incorporates a specific sentence. An MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, not merely a sentence cap or range. So for example, the agreement couldn't be an agreement to a range from, say, probation to 2 years. It would have to include a specific amount of active time, if any, such as 1 year, suspend all but 18 months, or perhaps 1 year, suspend all but 32 days with credit for 32 days. And in that case, you know, the specific amount of active time would be essentially 0 moving forward. Now, the court has the discretion to accept or reject the plea. And then the agreement is binding on the court under Maryland Rule 4-243 subsection C if the court accepts the plea. Now, an additional qualifier is the role of corrections options. Now, sentences to corrections options programs are deemed compliant provided that the initial sentence plus any suspended sentence, so essentially as long as the total sentence falls within or above the applicable guidelines range, and the case does not include crime of violence, child sex abuse, or escape. So this is the exception I mentioned earlier where we do consider suspended time. Now, corrections options allow judges to utilize a broader range of alternatives to incarceration while still remaining compliant with the guidelines. So corrections options include, for example, home detention, inpatient residential treatment, drug court. And again, if one of these corrections options programs is imposed, as long as the total sentence falls within or above the guidelines range, it would be deemed compliant. And then finally, time served. So sentences in which the offender received credit for time served with no post-sentence incarceration time And if the amount of credited time exceeds the guidelines range, it would be deemed compliant. All right, so next we're going to turn the discussion to MAGS considerations. I just want to point out a couple of features and a couple of things to keep in mind regarding MAGS here. Now, the first feature I want to point out is this reconsideration modification or 3-judge review for COV sentences feature. Based on some conversations I've had with practitioners since we deployed this almost 2 years ago, a lot of people actually don't know that it exists, and it's going to help you and streamline the whole worksheet initiation process. So I want to talk about it to make sure everyone knows. As we talked about earlier, in addition to original sentencings, we also collect worksheets for reconsiderations, modifications, and 3-judge panel reviews for crimes of violence if there was an adjustment made to the original active sentence as a result. Now, by guidelines rule, the guidelines for the upcoming reconsideration should be the same as they were for the original sentencing event. So prior to this feature being deployed, you used to have to initiate a new worksheet for the upcoming reconsideration that essentially matched the guidelines calculation for the original. This feature now streamlines that whole process for you, as long as the original worksheet was submitted in MAGS, which most jurisdictions, MAGS has been deployed in most jurisdictions for a couple of years at this point, so there's probably a good chance the original worksheet was submitted in MAGS. So how does this feature work? First thing you would want to do if you're initiating a worksheet for an upcoming reconsideration, you want to see if the original worksheet was submitted, you would check this little box here and then search by the case number, click search. So in the screenshot here, you can see I got a return for a John Smith with a case number 1111, and I can see it was sentenced back in 2023. I can also see, just based on the text here, that it was submitted, and there's this little copy icon next to it. So if you want to copy the original worksheet for the upcoming reconsideration, just simply click that copy icon, and you would be brought to the offender information tab here. Now, much of the information that you see on offender information, offender score, list of offenses, it's going to pre-populate based on the information that was submitted on the original worksheet, which is great for you, less work that you have to do. So really all you would have to do would be to enter your name as the worksheet preparer, title and agency. You can make changes regarding PSI representation status as it's applicable to the upcoming reconsideration, and then any victim related information you can reflect there. But that's pretty much all you would have to do to utilize this feature. So I wanted to point that out. Okay, jumping back to the home screen here in MAGS. If you've attended my past trainings, you know I've talked about this many a time, but when you have multiple criminal events, they're often have different case numbers, different offense dates. But when there are multiple criminal events being sentenced together in front of the same judge on the same day, that means they constitute one sentencing event. So one set of sentencing guidelines should be initiated for that event, meaning you click this add new button one time. And then when you get to the list of offenses tab, that's where you can add all of that unique criminal event and case number information. Now, if a multiple criminal event, single sentencing event scenario is initiated properly, if you were to go and search, in this case, let's say a John Smith, generally from the home screen here, you can see I get a return for two case numbers, 1122, 2233. And if I look to the worksheet ID field, you'll see that they share the same worksheet ID number. And that's how I know that that multiple criminal event, single sentencing event scenario was initiated properly. Now, let's say you went and clicked the add new button for this first case number, then went back to the home screen, clicked add new for the second case number. That creates two issues. The first and most major issue is that if you're initiating multiple criminal events, single sentencing event scenarios separately, the judge is not being presented with a proper overall guidelines range. So we want to make sure that doesn't happen. The second issue comes into play when judges and their court staff go to submit the worksheet. They'd be able to submit the first worksheet, then when they get to submitting the second worksheet, they actually get a duplicate error message. It won't allow them to do it, and then they have to contact us and we combine it for them and email them back a revised PDF. So we want to get ahead of that prior to sentencing. Which leads me to this duplicate worksheet message, which some of you may have encountered at some point here. So in the scenario we were just looking at where I had two different case numbers here, again, I said if we went and created one worksheet for case number 1, then went back to the home screen and created a second worksheet for case number 2. When you got to the offender information tab and clicked save on that second case number, Mags will now give you this duplicate worksheet message. It's going to say, this information matches the same information as another existing worksheet ID. And it's just reminding you, like, hey, if the worksheet that you're initiating now is being sentenced with this already existing worksheet / case number, you want to click the select button here, which is going to bring you to that already existing worksheet ID. And then from there, you go to the list of offenses tab, add this second, third, fourth, however many case numbers that you have to add to that same worksheet ID number. Now, that being said, it's possible that these could be true separate sentencing events. So maybe the case, the second case, or it's going to be sentenced on a different date than this case number here. If that's the case, you can just click the green button, which will allow you to continue initiating the new worksheet for the new sentencing event, and you can go on your way. But that's how the duplicate worksheet message works. And it's really just to catch multiple criminal events, single sentencing event scenarios so that we know they're being initiated properly prior to sentencing. Okay, the last feature I want to point out is relatively new. It was just deployed a couple of weeks ago. We were seeing that some practitioners were mistakenly entering birth dates as offense dates, which wouldn't be possible. That would make the offender 0. So we put this little check in place, and basically, if you happen to enter an offense date that's within 13 years of the date of birth that you entered on the offender information tab, Mags is just going to give you an alert saying they entered offense that offense date would make the offender too young to please correct it before proceeding. So just a nice little check in place to make sure that, again, we're getting as much accurate information as possible here. Okay. So that wraps up. I know I went a couple of minutes over. I said I tried to cram as much information as I could, and I hope you all found that to be helpful. Let me just touch base real quick with my colleagues. Bella, Sarah, is there any outstanding questions that we should address?
Yeah, I have one that I was about to type a response, and I can just give you the response. So somebody asked if a defendant is being sentenced for 2 completely unrelated offenses on the same day, then are we supposed to only create one worksheet? And that is correct. You would create those 2 offenses within the same worksheet ID in MAGS. You would just indicate, though, that they are different criminal events. So you would assign one criminal event number 1, the other criminal event number 2. And when you actually look at the PDF and print it out, because they're separate criminal events, they will be on separate pages. But that's how to properly combine them in MAGS.
Yes, still one worksheet ID, but if multiple criminal events in totality, you would see multiple worksheets, each one corresponding to their respective criminal event.
Oh, and let me attach the presentation one more time.
Thank you, Sarah. And at this point, is any other questions that anyone wants to ask? You can feel free to unmute yourself, ask your question. We're happy to answer anything. I'm not seeing anything. Okay. Okay, yep, and I just saw Sarah sent the presentation through one more time. If you want to download that, just keep it for future reference. Okay, well, thank you all so much for attending this training. If you ever have questions, feedback, please feel free to contact us, 301-403-4165, or our general email account, msccsp@umd.edu. If you reached out to us before, you know I'm usually the first point of contact for the commission and always happy to help with any questions that you have. So with that, thank you all again and enjoy the rest of your day.